No, I was going to ask you, do you think
sorry,
it was
Jim, could you say that
arrogance
again?
over time? This was just the way business was done with his law firm and with his time as chairman of the finance committee, that he just got sloppy?
You know, when you use the words, this is the way business was done, you know, frankly, Gary Chico's testimony was important to me just watching this. And it seemed like it was put in for a reason, and that is to show that this was not atypical of what was going on in the city of Chicago.
Let's explain to viewers what that conversation was. That was Ed Burke on a secret recording with former mayoral candidate and a political figure in his own right, Gary Chico, where Burke said, hey, you know, this company that we're trying to get some donation money from isn't really doing what we're asking them to do. Maybe we need to check on their driveway permits. And what that did, I think from the prosecution standpoint, and as you just underlined, indicates that Burke treated this as sort of his mechanism, his ticket to ride, that may or may not be limited to just these 4 schemes.
You know, I guarantee you that the FBI agent that was listening to that conversation put a big red flag on it so they could show it to the U.S. Attorney's Office and say, hey, I think this may help you in your theory of the case.
Irv, I've had a quick follow-up as well. Several of the legal sources I spoke with going into this verdict talked about the repetitive nature of many of these counts and many of these charges. I'm hoping you can maybe explain to us how they got the jury to this guilty verdict on each count, because it was important for them to reach agreement on these so-called predicate charges, right? So this was not just the single charge. They had a lot more to consider. Maybe you can explain how those predicate charges worked.
So if you look at count 1, which is the RICO count, you have to look at it as the umbrella. And everything, all the charges were incorporated with respect to Burke in that umbrella. And then they were broken down individually on all the subsequent counts 2, 3, 4, 5. But they needed to show at least 2 of those racketeering acts guilty beyond a reasonable doubt in order for the count 1, the racketeering charge, to sustain a conviction, to be found guilty of that. So it's, frankly, you're right, there's a repetitive nature of this, under the umbrella together, and then separately as different counts alleged in the indictment.
Many of those also, legal analysts said that they, on the way in, figured he would probably get clipped on some of these. You touched on it a minute ago. Were you surprised that he was guilty on all but one?
I was not surprised because, you know, Solis's testimony, the tapes from Solis were so powerful. And that's why, frankly, there's a reason that Burke couldn't take the stand in his own defense. And that is, he wouldn't be able to explain the words that he used. What about the tuna? The cash register hasn't rung yet. There's no way for him to explain that. So that's why he couldn't take the stand. So am I surprised that it came in uncontradicted by the government and it led to a conviction? Absolutely not.
But this conversation speaks to, I think, the larger conversation that we've talked about, Irv, which is the raw tonnage of information that this jury has had to go through, not the least of which are the 300 plus pages of jury instructions. We talked off camera yesterday. Juries, time and again, prove they take this stuff very seriously. Sometimes outsiders look at the legal system with a jaded eye, but I know you have said that despite it being so complex, this jury's doing what most juries do, and they are taking it very seriously.
You know, a lot of people say that when a jury is out this long, that means they're fighting back there. I don't think that's the case with this particular jury. I think they were going through each count, going through how each count applied to each defendant, and the fact that they made a split decision on several of these says that they were really using their brains and trying to come up with an appropriate conclusion. Jurors sometimes, you know, get along great. There's one jury in Cook County from 30 years ago. They get together every year as an annual event. They stay in touch with one another. It's my experience that jurors typically take this seriously. They're going to call themselves the Ed Burke jury from now on. And that's how they'll be known, actually.
And Joe Duffy, in his closing, said to this group of 12 people, this very well may be the most important thing you do in your life. Now, he was trying to set the table and amplify the dramatics, perhaps, in his client's favor. But nonetheless, to your point, these are those moments in time for these individuals. I just want to set the table here again for what I'm seeing behind our camera. There is is a bank of microphones. We are waiting to find out whether or not we're going to hear from any of the defendants here, obviously Pete Andrews or Ed Burke, any of their attorneys, the U.S. Attorney's Office, or any of the jurors who are all still upstairs. The jurors are in with the judge, we are understanding. She's thanking them for their dedicated service, Joe, and so these are the moving parts that we're waiting for here in the next hour or so.
Right. Chris, as we wait for that, can you lay a little more of the foundation for us as far as the other two defendants in Peter Andrews and Charles Quay, their connection to this case? Obviously, Burke was the headline. Their connection and why, in the end, Andrews was found not guilty on everything and Quay basically was guilty on everything.
Yeah, so great point. We're sometimes in the weeds where we need to zoom out, and Ed Burke is touching all four of these so-called episodes. What's happening is that Ed Burke was touching all four of the episodes. Pete Andrews was only involved in the Burger King scheme. That, of course, is the scheme where Ed Burke, now we can say by a jury's ruling, tried to extort a billionaire Texas-based Burger King franchisee to say, hey, listen, I will help you with your permitting if you hire Clafter & Burke tax law firm to do your business. That was the machine by which Burke kind of orchestrated payment. So Pete Andrews was only involved in that part of it. Pete Andrews was limited exclusively to the Burger King scheme. And what the jury found, and there were a lot of pieces and parts to the closing from Pete Andrews' team, but I think what was most salient to those of us who sat through this every day was that the FBI came to Pete Andrews' home at the same moment that Ed Burke's offices were being raided, both at City Hall and in the 14th Ward. They went to Pete Andrews and they asked him questions. And the questions they asked him, the order in which they were delivered, the way they presented it, the pictures they showed him of those Burger King franchisees created enough doubt in these jurors' minds to say, you know what? Pete Andrews, he was told that their name was Dehani and it was Dehani. He showed them pictures, the FBI showed him pictures of two gentlemen who don't look like the same person he met 17 months prior for 27 minutes. So what the jury, Joe, I think came back with was saying, hey, you know what, I think the FBI may have tried to be a little too cute in trying to get Pete Andrews to kind of fall into their trap. Lastly here on Charles Quay, he was only limited to the fourth of these four schemes, and that is the Binny's pole sign up in Portage Park. He, of course, the developer of that mall who was trying to use Burke's influence to get his needs met, and Burke again asking, and got in that case, a contract signed with Charles Quay to work with Clafter & Burke, Burke's tax law firm.